Okay, we're going to get started. I want to join everybody in thanking Director Ryder and my colleague Andy Cohen and our Dean Mark Miller and Bernadette Wilkinson for putting together a wonderful panel, and to all of you who came and to all the panelists. It's been an incredible day, and we'll try to finish with a flourish. I have a few anecdotes I want to share about the chief. As you heard, I think earlier today, he came here for 13 years during the so-called Hugo Black visit and would teach a 2-week course to our students, which was an extraordinary opportunity for them to have the chief as a teacher. It was classic Chief Justice Rehnquist, facts, facts, facts. It was a history of the Supreme Court. It was very scary for the students, I think, being called on and the like, but I think it was also, I know that it was a capstone for a lot of them to have that opportunity. I was the dean here for 10 years, and what Mark I know knows, and anybody in an administrative director kind of capacity knows, is not all guests are easy. And having a member of the United States Supreme Court here for 2 weeks, you might worry about how that's going to be. There was nobody more unassuming, easy to please, predictable, no drama guest of the college than Chief Justice Rehnquist. His visits were predictably in the terms of the course itself, thanks also to Associate Dean K. Kavanaugh. It went smoothly. He would give what he expected during the visit, one basketball game, and would go see our unbelievable Wildcats play. Breakfast at Denny's with one of his very close friends whom he knew from the days when he lived in Phoenix. Back in the day when his physical ability enabled him to do it, he would play tennis. He would have office hours frequented by students who are not easily terrorized, and a handful of colleagues who had those same characteristics. Lynn. He even showed up once at a law and literature class at Kenny Heglin's home. And so for the 2 weeks here, he really was a colleague, though in the way that you knew his deportment and his style. You heard earlier in particular from judges who served in his wake. He was precise. Now we saw that every time his visit began with breakfast, and he would order the same thing every year. He'd order pancakes and tea, and he'd say, "So what's new at the law school?" And you'd lean in and start babbling, and he'd go, mm-hmm, mm-hmm. And then we'd say, "So what's new at the court?" And he'd say almost nothing. And then at the end, as though the light had gone on in the courtroom, he decided when it was over, it did not matter if you were mid-sentence, nothing. He would just get up and say, "Thank you." And off he went. You said he was unassuming. Once he forgot his pajamas. And so the person who was assisting him with the visit said, "Well, I'll take you to the store." And they went to Mills Touché. Now, this is a high-end men's store of nice clothing. He walked in and said, "No, no, no." He said, "Don't you have a pennies?" And off they went to the mall. They took the Chief Justice of the United States to the mall to get some inexpensive pajamas. He was unflappable. We've heard some stories about Bush against Gore. When he came here for his 2-week visit, Bush against Gore had happened. And after that, there had been some sort of a threat to Justice Scalia when he was on another campus. Well, our police departments, God bless them, decided that not on their watch was anything going to happen, and so at my office arrived a fellow, 2 of them, in SWAT clothing. They looked like giant Ken dolls, and with SWAT written across their backs, and he said, "We promise to be unobtrusive." He's agreed to do a workshop on revisions to the discovery rules. That's how exciting the program was. The SWAT team's on the roof. Elliot Weiss, one of my colleagues, looks out of his window at the law school, and here's the SWAT team being unobtrusive. We go to the chief and we explain what's happening, and that it's his for his own. He could have cared less. He didn't want the security. He just marched in, did his job, marched out, and that was that. He also did have the accent that was referred to earlier, though I never noticed it. went down by Emos there, hey, say. You know, and if you've been to Wisconsin, see, that's how you talk. I'm from there also. All right. He was funny. I haven't heard enough about that. He was really funny. But he was funny in a way that was itself understated, the witticisms, and it was never cruel. There was a lot of puns and sort of plays on words and that, like, he was very, very quick, and so he was fun to be around. He was also terse. When he'd say, we'd say, so what's happening at the court? Apropos of this panel, pending that term was Locke against Davey. I felt I'd waited my whole career for this case. And I thought it was this perfect mix of everything that in the First Amendment area, the religion area, and equal protection, actually, we were waiting for it. I said, so the Locke against Davey case. And he looked at me blankly. The Locke against Davey case. And he goes, oh, that scholarship case. The end. And then we knew how it came out. Maybe you'll talk about it since he had something to do with that case. It was a pleasure to host him. You didn't have to agree with him. I certainly did not. But you grew to care very much about him, and we're very grateful for his very proud of his affiliation with the college and his generosity to the community and to our students. On the substantive impact, before we get into this, I want to say just two things. There are two, we couldn't, especially with the idea of the center, of the structures of government, cover all the areas in which he has left an imprint. But there are two that I would want to mention. One that I think was a terrific success by his lights, and the other that I think he would consider a failure. The success is, maybe more than any other member of the court, I think that William Rehnquist reduced the viability of constitutional arguments by making the state action requirement harder and harder to satisfy. And it's structural. So you can talk about the relationship between and among branches of government, but to say the Constitution doesn't go there because it's private and to declare it thus is a profound, I think, institutional and societal impact kind of decision. And I don't think anybody had more of an impact on the narrowing of the state action doctrine than did Rehnquist. A second area in which he failed was the commercial speech doctrine. And if you want to ever see Cassandra in action, you read the opinion in which he's horrified, just horrified, that we're going to extend freedom of speech to commercial speech. That's ended up being one of the biggest stories, I think, of the First Amendment these days, is the reach of the First Amendment to areas of regulation that previously were immune from First Amendment inquiry. He predicted ads for antibiotics on TV. I can only imagine him watching an ad for Viagra. I can't even think about it. But that was one where he did not prevail. And so I think that there's a lot more that we can continue to talk about in the years ahead about his imprint, and there may be ways in which even those areas in which he didn't succeed, we'll see, might be the answer to where it ends up going down the line. Okay, apropos of Locke versus Davey, we're going to be, this panel, you're very lucky to have them, is going to be talking a lot about the Establishment Clause, though not exclusively. It assures, many people assume, strict separation of church and state. I think that is a hopelessly misleading way of talking about what the doctrine actually does. I think it's been a steady erosion of any wall between church and state, especially since the early 80s, for good or ill. And I think he did contribute to that as well. It's going to be interesting to hear the panelists talk about it. I think those who would describe the United States Supreme Court as captured by godless secularists, it's just inconsistent, I think, with the opinions since the 80s. And those who fear that there's a war on Christmas, I think these are the tiniest troops I've seen, tiny, tiny troops fighting the war against Christmas. But let's see what they have to say. Rick Garnett is from Notre Dame. He was clerk for the Chief Justice in 1996. He also clerked for Judge Arnold, a graduate of Yale Law and Duke. He worked for Miller Cassidy. He's also spent some time in Phoenix. His father was the city attorney of Scottsdale, sorry. Scottsdale, ooh, high cotton. He's one of the most prolific scholars in the religion field in the United States and really and beyond. He runs the new Church, State, and Society program at Notre Dame. He has a book, Two There Are, and he has a phenomenal body of work on the topic of religion. And he's also a terrific person who can engage on important and controversial topics while reaching across divides. Barry McDonald, to his right, is here from Pepperdine. He was an '89 clerk for the chief. He also clerked for Judge Logan. He's a graduate of Northwestern Law. Loyola Chicago, he's worked for the State Department, worked for Gibson Dunn, he too, and I've read the scholarship of all three of our panelists with enthusiasm and envy. Numerous terrific articles on the First Amendment. He's also worked in the field of copyright law and common law more generally. Coraline, happy birthday to you. Channeling my inner Rehnquist here. It is her birthday. Professor Corbin from Miami Law, graduate of Columbia Law and Harvard. She worked for clerk for Judge Michael. She's done a tremendous amount of work for the ACLU. She was a public interest fellow at Sullivan and Cromwell, and she's just flown in here today, where she was yesterday at Emory Law School, where they had a major conference on the First Amendment, which is some evidence of how important her work has become in relatively short order. Her national influence is already established but continuing to grow. She works at the intersection of free speech and other liberties, and she's done provocative work on the status of atheists in American law and society and doctrine. We're going to start with Rick and then go to Barry and then end up with the birthday woman to my right.
Thanks very much. The Dean's mention of Wildcat basketball requires me, as an employee of the University of Notre Dame, to make some kind of sports joke, too. I had the chief out to Notre Dame twice when I was an untenured professor for the Michigan game. And I figured that given that, the chief was a Big Ten fan, he would join me in cheering for the Irish against the Skunk Bears. And he did. And at the end of the second game, so he'd come out twice, I said, "So, Chief, what do you think?" And he's like, "Well, Rick, I hope I never hear one of those goddamn fight songs again." So it's wonderful to be here with you. I love coming to Arizona. I'll take any excuse to come back here. Please invite me often. I'm visiting from the land of lake effect, but I like to think of myself as an Arizona lawyer, like my father, like the chief. I took the Arizona bar almost 20 years ago here in town. That was my least happy memory of being in Arizona, I think. I think the lawyers who've been my role models in the profession, people I worked with and for at the Meyer Hendricks law firm and the Osborne Maladon law firm, people like Brent Duckelman was here, and Chief Justice Bales, and also I think the chief. The chief for me was a role model more than an ideological hero, although I tended to agree with him on a lot of things. I found him to be a real lawyer's lawyer. He didn't have much interest in talking to my fellow clerks and I, or to my students, about culture war things or ideological things or even philosophical things. He wanted to talk a lot about how important it was to read carefully and to think hard and to write clearly. And he really cared about making sure young lawyers learned about the importance of work-life balance and taking time with family and taking time to contribute to your community. And I'm pretty sure that those of us who had the privilege of working for him and all the students who had the privilege of learning from him took those lessons away. So thinking about our topic today, it probably would have come as no surprise to anybody at the time when President Nixon nominated Bill Rehnquist to the Supreme Court that he was going to have his eye on the criminal procedure ball, right? I mean, President Nixon didn't exactly make a secret of his interest in law and order, and I think the chief, when he was in the DOJ, didn't make a secret of his interest in those topics as well. And I think probably most people weren't all that surprised that the chief took a close interest in federalism questions. He'd been interested in those questions when he was doing master's work in political philosophy. And again, I think as our wonderful first panel today showed, he had a very important influence in that area on reminding us of the importance of the Constitution's structural features. But I think it might not have been foreseen at the time Rehnquist was nominated that he'd have such an influence on the court's interpretation and application of the religion clauses. But he certainly did. Professor Kent Greenewalt, who's I think the Dean of Law and Religion Scholars, once remarked that Rehnquist, or the Rehnquist court, quote, turned the constitutional law of religion upside down. We've moved, he said, from expansive readings of both the religion clauses to narrower readings of the free exercise clause and of important aspects of the establishment clause. Now, in my view, in guiding these moves that Kent Greenewalt identified, Rehnquist, for the most part, turned the constitutional law of religion right side up rather than upside down. And in my judgment, he left the court's religion clause doctrine better than it was before. That is, better rooted in the Constitution's text, history, and structure than it was before. But in any event, whether I'm right or wrong about that, the moves Professor Greenewalt described happened, and I think they happened in no small part because of the chief. So why is this true? Why this surprise in terms of this area of impact? Why is Rehnquist's legacy so clear in the religious liberty and church-state context? I don't think it's because William Rehnquist was strongly motivated by personal religious commitments or by a sense of his role in a culture war or something to repair the law of religious freedom. My impression of the chief was that he was a sincerely and thoughtfully religious man, but he wasn't one to wear his faith on his judicial sleeve. That space was reserved for stripes. Nor was he considered or criticized, unlike, say, Justice Scalia, in terms of his faith. No one ever talked about the chief as being, he's the Lutheran justice, the way they might have with some others. Here's a quick story along these lines. So during the year I clerked, and I think for a lot of my colleagues as well, part of the routine, one of the really nice parts of the routine, was this daily morning meeting with the chief and the clerks. And at the appointed hour, which was very civilized, we would get together in the office around this small desk and take stock of upcoming cases and take stock of opinions he was writing and opinions he was waiting for other justices to write, and then, of course, important things like college football rankings and our Oscar picks. And but one morning, the chief was clearly agitated, and it was unusual because, as we've heard, he was such a mellow guy. But he was irritated by something in the Post. And what it was that there was a story in the Post that day about the annual Red Mass, which, as you know, in most dioceses around the country, coinciding with the opening of the court's term, there's a Mass for lawyers. And the one in D.C. has become a pretty big deal, and a lot of the justices go. So there was a picture on the front page of the chief and a few of his colleagues, and in the picture, the chief is seated and his head is somewhat bowed, according to the caption, bowed in prayer. And the chief, again, irritated, said, I wasn't praying, I was just reading the program. As I see it, the chief's religion clause votes and his religion clause opinions are not best understood as just the emanations of religious commitments, but I think they're very consistent with his judicial philosophy overall. I think he provided a very revealing sketch of that philosophy just a few years after joining the court in a very short essay called The Notion of a Living Constitution, which came out in 1976 in the Texas Law Review. Now, we've talked a lot about the chief's philosophy in a lot of areas today, but as I see it, that philosophy reflects, among other things, two really bedrock commitments. One is that I think he rejected the idea that the court's role was to be the, quote, voice and conscience of contemporary society. I think he did not believe that the court's role was to serve as, quote, a council of revision, armed with a roving commission to second-guess Congress, legislatures, and state and federal administrative officers concerning what is best and just. A second big theme, and we heard a lot about this in our first panel, following James Madison, Rehnquist believed that the structural features of our Constitution, so federalism, separation of powers, and so on, that those structural features are essential to the health of our fundamental liberties, that they're just as important, perhaps more important, to protecting those liberties than the listing of rights in the Bill of Rights. And he thought that those structural features of the Constitution shouldn't be left entirely to the political branches to enforce. And Chuck Cooper said something about this earlier in the first panel. He thought there was a role for the court to play in not providing the country with the substantive answer to divisive moral questions, But there was a role for the court to play in kind of policing the boundaries of power, both vertically and horizontally. So I think running through the Chief's opinions on a whole bunch of questions, from assisted suicide and abortion to Christmas displays and so on, was a pretty consistent, nobody's perfectly consistent, but a pretty consistent fidelity to the idea that our Constitution leaves a lot of important and difficult and even divisive decisions to the American people, to democratic majorities. And also a fairly consistent fidelity to the idea that our Constitution relies on structural features that need to be enforced by courts. Okay, so turning to religion now. As you've heard, the Chief wrote a lot of opinions. He wrote more than 458 opinions for the court, 376 dissenting opinions, 96 concurrences, and 33 opinions concurring in part or dissenting in part, and still more. So no surprise, he had to write a few about the religion clause as well. I think that work illustrates and reflects those two basic points from his judicial philosophy pretty well. That is, I don't think the Chief regarded the religion clauses as authorizing, let alone requiring, wide-ranging close supervision of the decisions of politically accountable actors or the outcomes of democratic processes. It's not that religious freedom isn't important, but I don't think he believed that the importance of religious freedom demanded that courts take complete control of the matter. So I think we can group the Supreme Court's religion clause cases helpfully, not perfectly, but helpfully, into four broad categories. The first category, well known to many of us, has to do with cases dealing with public funds and religious institutions or activities. Locke v. Davey, for example, is the name mentioned. The issue in these disputes, obviously, is whether the funding or the assistance in question, whether it's the loan of textbooks or the bus services or school vouchers or whatever, whether the support in question constitutes an establishment of religion. Second category. These are controversies over whether or to what extent governments are allowed to acknowledge religion through their expression or symbols or commemorations and statements and so on. And we could lump the school prayer decisions in this category, and also cases involving things like displays of the Ten Commandments or nativity scenes on public property and so on. The third category, obviously much in the news lately, involves disputes about the extent to which governments should accommodate, or more carefully, disputes about the extent to which governments may or must accommodate religious believers and religiously motivated conduct through exemptions from generally applicable laws. And the famous Peyote case of Employment Division versus Smith is one of these cases. The infamous, perhaps, case from 1878 of Reynolds versus United States involving a bigamy conviction is another. The fourth category is kind of amorphous, and this is actually the category that tends to interest me most, but its boundaries are quite fuzzy. I call them the church-state entanglement cases. But this category might include the 1969 Blue Hall Church case, in which the court decided that the Constitution doesn't allow a secular court to, quote, determine ecclesiastical questions. The recent Hosanna Tabor case might be another example of such a decision. But these are cases where the controversy really has to do either with the exercise of political power by religious authorities, which isn't supposed to happen, or they have to do with interference by secular authorities with the internal workings of religious institutions. So hence this word entanglement. Now, not all of the court's important decisions can be lumped in these categories, but I think most of them can. So how did the Chief deal with these categories of cases? Well, let's start with the public funding cases. William Rehnquist joined the court in January of '72, about 6 months after the announcement of the famous Lemon test, which is sort of tottering and always on its last legs, but still, again, as Scalia would say, zombie-like rising from the grave to terrorize little children. In Lemon, the court concluded that several legislative efforts to subsidize education in parochial schools amounted to unconstitutional establishments of religion. And this decision seemed to represent a little bit of a move away from the approach that had earned majority support just a few years later in the Allen case, where the court had said that textbook loans to parochial schools were okay. But Lemon was extended, and Allen pretty much abandoned, at the end of Rehnquist's second term in the Nyquist case. In that decision, the court struck down a tuition reimbursement program, kind of like a voucher program today, for children attending religious schools. And the nearly brand new Justice Rehnquist dissented. He said, and forgive me for the long quote, but I think it's important, he said, "The increasing difficulties faced by private schools in our country are no reason at all for this court to readjust the admittedly rough-hewn limits on governmental involvement with religion, which are found in the First and 14th Amendments. But, quite understandably, these difficulties can be expected to lead to efforts on the part of those who wish to keep alive pluralism in education to obtain, through legislative channels, forms of permissible public assistance, which were not thought necessary a generation ago. Within the limits permitted by the Constitution, these decisions are quite rightly hammered out on the legislative anvil. If the Constitution does indeed allow for play in the legislative joints, those are words that he would use in Locke versus Davey, the court must distinguish between a new exercise of power within constitutional limits and an exercise of legislative power which transgresses those limits. I believe the court has failed to make that distinction here. Well, for almost 30 years, Nyquist served to block a lot of voucher-type programs and other forms of aid to private and religious schools. But all of this changed, and obviously I'm making a long story short, all of this changed in 2002 with the Chief's opinion in Zellman versus Simmons and Harris, which really did kind of summarize things that he'd been saying for, again, the better part of 30 years. In that case, the court upheld Ohio's small school choice program, which provided scholarships to some low-income students in Cleveland. And in so doing, the court abandoned the Nyquist approach, although it didn't explicitly overrule the decision. And as Rehnquist had long been urging, it embraced this more deferential approach, which focused on the neutrality of programs and didn't worry excessively about whether resources ended up making it easier for children to attend parochial schools. Now, this development, I want to emphasize, is not something simply that happened on Rehnquist's watch. I think it happened in no small part because of things that he wrote, because of things that he did. In a number of important decisions, he presented and defended the view that the constitutions may, in Locke v. Davey he would tell us that they don't have to, but they may allow religious believers and institutions to receive otherwise available public support. For him, quote, equal treatment was not establishment. Second category of cases, those presenting the question whether the Establishment Clause is violated by displays of religious symbols or by too many elves next to too many nativities and so on. In this area, there hasn't been, I think, the striking transformation or sort of cleanup operation in doctrine or outcomes that we saw in the funding cases. Instead, the court has been content and still seems content to muddle through, for better or worse, guided by a grab bag of standards that manage somehow to operationalize various justices' intuitions about how these cases should come out. These justices' intuitions include a sense that some acknowledgments of religion are permissible, but not all, that subtle coercions to religious expression are unconstitutional, but not everything is a subtle coercion, and that government should not make adherence to a religion relevant in any way to a person standing in the political community, except when it does. So Justice Rehnquist's votes and writing in this area reflect his view that identifying the permissible extent of government acknowledgement of religion is a matter primarily for the democratic process and for political actors. And I think Professor McDonald is going to talk more about the implications of that in his remarks. For me, two of his opinions in this area stand out. The first is a 1985 case called Wallace versus Jaffrey. That might be his most cited and most studied law and religion opinion, not his most influential. But in that case, after noting that the court had long been guided by this image of Jefferson's of a wall of separation between church and state, Rehnquist quipped that, quote, it's impossible to build sound constitutional doctrine on a mistaken understanding of constitutional history or on a misleading metaphor. He then proceeded with a sweeping critique of the historical premises of the court's no establishment doctrine and of the doctrine itself. He set out a counter-narrative which was thoroughly researched and heavily footnoted and has not had that much influence on the court's direction since then, although scholars continue to argue about it. More recently, in his very last opinion for the court, Rehnquist explained in Van Orden versus Perry why a 6-foot-high monolith inscribed with the Ten Commandments on the grounds of the state capital of Texas did not unconstitutionally establish religion, even though a different group of justices had just told us that same day that a display of the Ten Commandments on a courthouse in McCreary County, Kentucky did. The chief told us that the court's role and the Constitution, he said, quote, require that we neither abdicate our responsibility to maintain the division between church and state, nor evince a hostility to religion by disabling the government from in some ways recognizing our religious heritage. On balance, all things considered, he said, we cannot say that Texas's display of this monument violates the Establishment Clause. As some of you might know, Van Orden and its companion case produced 10 separate opinions. And the chief noted, as the opinions are being handed down, that he didn't think they had 10 justices on the court. With respect to the third category of cases, these are the accommodation of religion cases. The change in the court's approach during Rehnquist's tenure was striking. And again, I think it was in accord with his thinking, although the main case, of course, as many of you know, was authored by Justice Scalia. So when Rehnquist joined the court, the rule that purportedly controlled, although some of us think it actually didn't, was Sherbert versus Verner. And there the court had invalidated the state of South Carolina's eligibility restrictions for unemployment compensation on the ground that by refusing to credit Mrs. Sherbert's religiously grounded reason for not wanting to work on Saturdays, South Carolina's rules significantly burdened her free exercise rights, were not justified by a compelling state interest, and therefore violated the Free Exercise Clause. During Rehnquist's first year on the court, the justices seemed to follow this approach in Wisconsin versus Yoder, when they ruled that the Constitution required the state to exempt Amish parents from certain compulsory attendance requirements. Rehnquist did not participate in Yoder, but it would become clear pretty quick that he did not believe the Constitution required exemptions for religious believers from generally applicable laws. So in a case called Thomas versus Review Board, Rehnquist dissented by himself before he was chief from the court's ruling that it violated the Free Exercise Clause to deny unemployment benefits to a Jehovah's Witness who was fired for refusing to accept a transfer to a factory that made tanks. And Rehnquist observed that the, quote, growth of social welfare legislation, which touches the individual at so many points in his life, makes it impossible to avoid conflicts between otherwise valid laws and personal religious objections. In his view, Sherbert was wrong, and, quote, whereas here a state has enacted a general statute, the purpose and effect of which is to advance the state's secular goals, the Free Exercise Clause does not require the state to conform that statute to the dictates of religious conscience of any group. Now, it needs to be emphasized that even as he was saying that, he also made clear that the Establishment Clause permits legislative accommodations when the legislature wants to extend them. So he understood the Establishment Clause as very rarely prohibiting legislatures from accommodating religion through exemptions. He resisted the idea that the two clauses should be read so as to, quote, narrow the channel between the Scylla and Charybdis through which any state or federal action must pass in order to pass constitutional scrutiny. In his view, quote, government assistance which does not have the effect of inducing religious belief, but instead merely accommodates it, does not impermissibly involve the government in religious choices, and therefore doesn't violate the Establishment Clause of the First Amendment. So again, Rehnquist didn't write the landmark Smith case, but I think Justice Scalia's opinion for the court certainly reflects Rehnquist's views expressed in that Thomas dissent. Most law and religion scholars, I think it's fair to say, disagree with Smith and with Rehnquist on this point. In my judgment, however, I'm the minority, Rehnquist's position is sound. But to say that accommodations are rarely required by the court is not to deny that they may and should be generously provided, as they have been, for example, in statutes like RLUIPA. A society that values, as I think ours should, the free exercise of religion will, if possible, try to accommodate religiously motivated dissenters and minorities. So Rehnquist shouldn't be understood as rejecting this idea. Instead, he believed that the particular text he was charged with interpreting didn't authorize him to invalidate or second-guess legislative judgments about how best to strike the balance of accommodation. And finally, the fourth category, this category of cases involving religious questions and church autonomy decisions and so on. Again, the line between these cases and other categories is not going to be sharp, but I do think the basic idea at the core of this category is pretty clear. The cases in this category generally implicate the freedom of religious communities or the freedom of religious institutions to define themselves, to govern themselves, to select their own teachings and, as we saw in Hosanna Tabor, their own ministers. A leading case might be, again, as the Blue Hole Memorial Church case, which involved a property dispute between rival claimants to Presbyterian orthodoxy. Justice Brennan had said, civil courts lack the power to determine ecclesiastical questions. And he said, if secular courts, quote, undertake to resolve such controversies, the hazards are ever present of inhibiting the free development of religious doctrine and of implicating secular interests in matter of purely ecclesiastical concern. Well, during Rehnquist's long tenure, the court returned only a few times to cases like this. But in one of them, a 1976 case involving the removal of a bishop and the subdivision of a diocese, Rehnquist wrote an opinion that was, I think, consistent with his approach in the three categories I've just discussed. Now, the facts and procedural history of the 1976 Serbian Eastern Orthodox Diocese case are appropriately Byzantine. The basic dispute, however, was over the control of the Serbian East Orthodox Diocese around Chicago, over control of the diocese's property, control of its assets. And Justice Brennan restated much of what he had written in the Blue Hall case and said the Constitution doesn't permit an Illinois court to second-guess the decisions of the church's own courts about who's in charge and who gets the property. This case involved a religious dispute, and the resolution of such disputes is for ecclesiastical tribunals and not civil ones, so said Justice Brennan. Justice Rehnquist dissented, sounding interestingly a lot like his former boss, Justice Jackson, in the Kedrov case 40 years before. Justice Rehnquist didn't contest the basis idea that there are a lot of good arguments for why civil courts should stay away from religious disputes to the extent possible. But he insisted that those arguments were no more weighty in this context than in all kinds of other contexts involving private intra-organizational disputes. And so in cases like this one, Rehnquist said, religious institutions can be regarded like any other private voluntary association. Well, I've argued elsewhere that this view is mistaken, and I'm sure the Chief was really bothered by that. In any event, whether I'm right or not, as I said earlier, Rehnquist's opinion was consistent with the themes and tone of his First Amendment decisions generally. Or maybe not. Maybe not. Rehnquist's judicial philosophy, as I suggested earlier, his approach to constitutionalism generally, might actually weigh in favor of a different approach to a case like the Serbian Orthodox Diocese case. How would that work? So remember his emphasis in Lopez and other cases on our Constitution's first principles. Our Constitution separates and divides power, he said, following Madison, in all kinds of textual and structural ways in order to, quote, ensure protection of our fundamental liberties. Well, what does this have to do with intra-church disputes about will the real bishop please stand up? Here's a possibility. Our constitutional experiment relies, he might have thought, not only on the separation and limitation of the national government, but also on the existence and the health and the autonomy, to some extent, of associations that are outside the state, that are meaningfully independent of the state. In other words, independent religious communities and institutions and authorities might play an important structural role, analogous to the role that Chief Justice Rehnquist thought that states play in our system. He might have thought that the goods and values that the First Amendment's religion clauses embody and protect are actually well served by a civil society landscape that's thick with churches and other mediating institutions of all kind, and by legal rules that acknowledge and capture their importance. God willing, I will someday have another chance to convince him on this point. Thanks.
Well, as we get my PowerPoint that I prepared to keep everybody awake at this late hour as we get it set, I just wanted to thank the Rehnquist Center, Dean Ryder, Professor Cohn, Dean Massaro for moderating this panel and for having us here for this very interesting and provocative discussion. Since everyone's given their Chief Justice anecdotes, I thought I'd give a couple of mine. I got to Pepperdine in 2000, and this story is legendary there, so I can't, confirm it scientifically, but it's told often that the chief would visit Pepperdine frequently, probably not because it was in Malibu, right on the ocean, but we would put him up at what was called the Pink Beach House that had been bequeathed to Pepperdine, and it was right there in Malibu, right on the water. The only problem was it also backs up right to PCH, as all the beach bungalows tend to do. And so the story is that he's sleeping in that pink bungalow one night, and some drunk driver speeding along on PCH just ran off the road and smashed right into that pink bungalow. And, the chief, very unfazed, so the story goes. It just said, no big deal, I'm going to go teach my class the next day, and he didn't even think a thing of it. So very unpretentious, non-assuming. I have also an anecdote that I am personally familiar with. When I started clerking, it was my first real job where I had some money, and back then, being a sort of a young man, I thought, well, now that I have some money for a car, I want to buy a muscle car. It's a lot of young men's dream. So I buy this souped-up black Pontiac Trans Am, right? And so, a couple days after we started clerking, the chief wants to get all the clerks and go to play tennis, as we did once a week down in Haynes Point, which is about 5 miles from the Supreme Court. And he's like, well, who's got a car here? And I go, well, I got one, but Chief, it's, I don't know if it's a car you want to be riding in. So I describe it and go, nonsense, let's go. So here we are tooling around through all D.C. with the Chief Justice of the United States in the front passenger seat of this souped-up black Pontiac Trans Am. But, so it was quite a funny image, but nonetheless, it was fun. More to the point of this discussion, so as you can tell from my title, Democracy's Religion, I completely agree with Professor Garnett's thesis that Chief Justice Rehnquist, in leading the court, effected a revolution in the religion clauses in terms of narrowing their scope to allow for more democratic majoritarian preferences to determine sort of the involvement between government and religion in our country. In fact, when we were getting ready for this panel, Dean Massaro asked for our abstracts, and so Professor Garnett and I sent them to her, and we're like, uh-oh, what are we going to do? Because we've written the same thing about how the Rehnquist court had done this. Of course, Professor Garnett's was much more eloquent, his account of it. So we like, what are we going to do? So I said, okay, you cover the Rehnquist court, and I'll sort of then start thinking about the legacy that the Rehnquist court left to the Roberts court, and sort of trying to tease out the normative implications about what, this trend towards, the involvement of majoritarian preferences in dictating the governmental religion relationship are going to have in the future. And so I just started thinking, trying to tease out the implications of this. So I would welcome your input after this, or when we get to Q&A. Okay, so as Professor Garnett said, one of the major accomplishments of the Rehnquist court was to sort of take the Sherbert compelling interest test for claimed religious exemptions from generally applicable laws, and in the Smith decision, effecting a revolution of that, turning it on its head to say we're not going to take claims to religious exemptions seriously as a free exercise matter any longer. They must be a matter of legislative accommodation now. And so, what we have now, one of the bequests of the Rehnquist court to the Roberts court, is that Roberts court free exercise decisions are really going to be a matter of not all, but I think the bulk of their decisions are going to concern statutory interpretation versus constitutional interpretation of what the free exercise clause requires. And that's evidenced by the fact that 4 of the 5 free exercise cases that the Roberts court will decide by the end of the by the end of this current term, 4 of the 5 cases will be statutory interpretation cases. Cases interpreting the Religious Freedom Restoration Act, which of course Congress passed, and which now, after City of Bernie, the City of Bernie decision applies to only federal government actions. RILUPA, which Congress passed in the wake of City of Bernie, to at least say as to prisoner accommodations and to local land use decisions at the state and local level, that's going to be driven by federal law in terms of the accommodations, and a number of state RFRA laws that have been passed. And if you consider the number of state RFRA laws that have been passed in combination with the number of state constitutions that still accord sort of a Sherbert compelling interest protection to claimed exemptions for free exercise of religion, you have a situation where, you know, roughly 31 or 32 states you know, either have a state RFRA or fairly strong protection for claimed exemptions from general secular laws. And so what this trend is going to mean is that, you know, the court's role is going to shift. Not totally, because you have decisions like Hosanna Tabor, which are still going to interpret free exercise as a matter of constitutional interpretation. But they're going to become mainly statutory interpretation cases, trying to discern the will of Congress in a RFRA case or a RILUPA case. So that's one of the bequests, is that the Roberts Court is going to be largely engaged in statutory interpretation. On the Establishment Clause front, Professor Garnett accurately described there how in the area of governmental aid to religion, the Rehnquist Court sort of bequeathed to the Roberts Court the doctrinal tool of neutrality to allow a lot more aid to flow to religious organizations, particularly religious schools, at the same time that it flows to public schools. On the sponsorship of religious expression front, Professor Garnett also talked about how, you know, the Rehnquist Court came up with sort of doctrinal developments to allow a lot more government sponsorship of religious expression in the area of, you know, holiday displays, et cetera. The court has sort of, and Ten Commandment displays, the court has sort of strengthened the historical secular exception for the government to be able to display those sorts of symbols in terms of government sponsorship of prayer. The Rehnquist Court didn't make as much of a difference as it did in the other areas, but it's still, with Justice Kennedy writing for the court and a number of the dissenters, including Chief Justice Rehnquist, signing on, saying that the appropriate test to assess prayer in the governmental context is really the anti-coercion test. Now, they disagreed as how that should apply, but they agreed on the anti-coercion test versus the prevailing Lemon test or the endorsement test. The anti-coercion test theoretically is going to allow much more significant government sponsorship of prayer than the other two tests. So, and my claim here is that the bequest to the Roberts Court is sort of these doctrinal tools and this momentum for a further narrowing of the Establishment Clause's restrictions on government involvement of religion. And as I'll talk about in a moment, I think the Roberts Court has taken full advantage of that momentum in its 5 Establishment Clause cases that it has decided to date. Okay, in short, as I say here, religious liberty is increasingly being defined as a matter of majoritarian democratic preferences. So what is that going to mean then? Well, I say we can think about this question in terms of religious liberty in general, asking in terms of shifting the focus from a constitutional analysis to more of discerning legislative intent and majoritarian preferences. What is the effect of that going to be on religious liberty in general? And then I think we need to ask ourselves, because a lot of, as we know, a lot of the Bill of Rights are designed to protect minority rights, we also have to ask ourselves what is going to be the effect on minority religious exercise rights as well of this sort of majoritarian trend. So in terms of free exercise liberty in general, my argument is going to be that, at least in terms of the evidence that we see so far, I think that free exercise liberty in general is going to be much more vibrant and strong in terms as a matter of legislative accommodation than it was when it was a matter of constitutional right. As Justice Scalia noted in the Smith decision itself, the Sherbert strict scrutiny under sort of the pre-Smith regime, when it was a constitutional right, this claimed exemption from generally applicable laws, that claim, this strict scrutiny test was really just applied in name only. In fact, only 5 of those 18 claims for an exemption from secular laws succeeded. And so it was sort of a very weak form of strict scrutiny. And I think this can be explained by what Professor Baker talked about in her talk earlier, which is sort of, when you're deciding matters of issues as a matter of constitutional right, the judge is sort of the end of the line, and it is sort of a rigid and inflexible approach in terms of future cases. But when you're deciding matters as an issue of statutory interpretation, now it becomes more of a sort of interbranch conversation. And so I think that when the court, even pre-Smith, was giving serious consideration to free exercise accommodation as a matter of constitutional right, it wasn't doing it in a very serious way for that reason. And so I think that, at least my argument is that the courts are going to be a lot more willing to interpret statutory rights broadly on this theory that, well, if the legislature, Congress, doesn't like sort of the balance that the court is striking in these cases, it can adjust the statutes to take into account that. And I think that this sort of more vibrant trend is evidenced by the Roberts Court statutory rulings to date, and I'll note those in a second. But it's particularly made possible by Justice Alito's recent opinion in the Hobby Lobby case, where he explicitly says that we're no longer going to construe RFRA. Well, no longer. We're simply not going to construe RFRA by reference to our pre-Smith First Amendment case law. We think what Congress wants to do is go further than that in terms of strengthening religious liberty, and we're going to adhere to what we believe is Congress's intent in this matter. Now, there's a caveat here, and that is that, of course, 18 to 19 states still have how much protection they're going to give to free exercise statutory accommodation. There's still an open question. So there is a significant gap in these 18 or 19 states. But even there, you still have RFRA and RILUPA applying to claim burdens from federal laws on free exercise rights. And you also have a number of exceptions that courts have read into the Smith decision, where they've said, we're still going to apply strict scrutiny to this denial of an exemption to generally applicable laws and cases, for example, when there are secular exemptions given and not when there are religious exemptions given. Or, as Justice Scalia wrote in Smith, when there are hybrid rights at issue that can combine not only religious constitutional rights but also, for example, free speech rights. And now you have this sort of Chief Justice Roberts writing in Hosanna Tabor, where it was argued that, look, the church at issue here in Hosanna Tabor should not get a free pass from anti-discrimination laws that the plaintiff was trying to apply there. And it was argued that Smith should apply. Roberts just, in sort of 2 paragraphs, just dismissed that argument and said, well, Smith was all about sort of outward physical conduct. This decision is about internal decisions about one's faith and mission. And so he kind of created this amorphous decision versus conduct distinction that I think lower courts are probably going to seize on in the future to create further exceptions to the Smith no constitutional scrutiny rule. So my bottom line is that even in these gap states, you still have some significant protection for religious liberty when you're talking about claimed exemptions from general laws. But there's one other caveat that I need to mention, and that is the New Mexico Supreme Court's decision in the Lane photography case, having to do with whether a photographer violated state civil rights laws by refusing to photograph a lesbian wedding. In terms of the claimed protection by the photographer under New Mexico's RFRA law, the Supreme Court of Mexico said, well, it doesn't apply to government-enabled private causes of action that incidentally burden religious exercise. But that seems to be a fairly isolated decision. The federal courts are split on whether, RFRA applies to private causes of action or not. So it's simply not clear to what extent the Lane photography reasoning is going to apply in other states, especially since New Mexico's RFRA law was written in terms of saying if a state agency were to impose a burden on somebody, then you should apply a compelling interest analysis. And most state RFRA laws, I believe, are not written with that specific sort of language, which allowed the New Mexico Supreme Court to reach the decision it did in that case. Okay, moving forward then, I think that we see this sort of more vibrant protection for free exercise liberty in the courts, the Robert Court's statutory decisions to date. The O Centro case, where the Robert Court sort of blessed an exemption for a Brazilian church to use hallucinogenic drugs as part of their sacramental rites, emphasizing that the government had a heavy burden in terms of proving a compelling interest. It had to be an individualized compelling interest that applied to that specific plaintiff and not sort of a compelling interest in general. Of course, we saw the recent Hobby Lobby case where Justice Alito talked about the expanded notion of religious exercise that Congress has written into those laws to take it further than it was under sort of the First Amendment law. And as Professor Corbin is going to talk about, the decision extended that protection to closely held corporations. The Court, in its discussion of what is a substantial burden on the free exercise of religion, to me seemed to be very deferential to sort of the plaintiff's claim in that case. And on the flip side of that, Justice Alito, his discussion sort of portends, I think, a real heightened scrutiny of whether the government has found a least restrictive means to achieving its purpose that doesn't burden somebody's free exercise of religion. And so all of this basically says that we're going to favor the plaintiff and put a heavier burden on the government when they seek to deny an exemption to generally applicable laws. Same thing in the recent Holt case about the Muslim prisoner's, the length of his beard. It seemed to me Justice Alito, writing for the Court again, gave the substantial burden claim of the prisoner sort of deference. He reiterated the government had a strong burden in terms of showing that it had a compelling interest in denying that prisoner the right to grow his beard a half an inch. And he also, again, emphasized that the government is going to have a hard case in terms of proving that there were no least restrictive means of sort of achieving their security ends in that particular case. So all of these decisions, I think, portending that statutory free exercise rights are going to be stronger than the constitutional rights were even under the pre-Smith regime. Okay, so I don't want to take up a lot more time, so I got to move fast here. In terms of free exercise liberty for minority faiths, it's really not an issue right now because all of these statutory accommodation laws that are being written right now are written in generally applicable terms. RFRA, RILUPA, the state RFRA laws, they extend to everybody, so majority and minority faiths alike. So the only question is, do we see that changing in the future? I don't see it. But let's just hypothetically say, okay, let's say that these Congress and state legislatures started repealing these laws or modifying them and sort of granting selective exemptions to majority faiths. What would be the position of the minority faiths at that point? Well, Scalia wrote about this in Smith at the end of the decision, and he said, as it says here, it may fairly be said that leaving accommodation to the political process will place at a relative disadvantage those religious practices that are not widely engaged in. But that unavoidable consequence of democratic government must be preferred to all this balancing mess that he wrote about. So in other words, he's basically saying, if you're a minority faith and you're not getting the exemptions that the majority faiths do, too bad. That's just an unattainable consequence or inevitable consequence of the democratic process. Now, I'm going to push back on that. I think Scalia was probably wrong because I think that there are strong legal arguments that if legislatures started granting majority faiths selective advantages and not granting sort of comparable accommodations to minority faiths, there would be strong legal arguments that would be unconstitutional. For one thing, in Establishment Clause cases, that basically claim when a legislator is granting an accommodation to a faith that it violates the Establishment Clause, one of the big factors the court considers is whether that accommodation has been granted neutrally, to all, faced across the board. So in that sense, I think that there's already strong sort of establishment clause law on the board that would say that majority selective preferences are going to be problematic. Secondly, you have the Equal Protection Clause. It has a whole line of cases that says if the government discriminates between various groups and makes it harder for them to exercise fundamental rights, like, the exercise of religion, then you're going to scrutinize it under a strict scrutiny test. So I think there you're going to have, you would have strong legal arguments that selective majority accommodations were unconstitutional. And finally, even if Congress or the state legislatures wanted to get around this and sort of just write facially neutral laws saying, for example, well, any faith sacramental use of wine is sort of exempted from alcohol and beverage laws. Everyone knows that that would sort of selectively advantage the Catholic faith. Well, could the legislatures get around sort of minority rights by writing sort of these sort of selective practice accommodations in sort of a facially neutral way? But even there, I think the court has shown its willingness in other key areas of constitutional law to look for underlying sort of purpose to either benefit or disadvantage people on the basis of race, as in the Arlington Heights case, or even in the Church of the Lukumi case, to look for an underlying purpose to disadvantage a particular religion. So I do think that you already have a lot of law on the books that would say that there are strong constitutional arguments that minority faiths would still be protected, even if legislatures were to start granting selective exemptions to majority faiths. How am I doing on time?
I think we need to.
Okay, yeah, so let me just wrap up here and say I have similar arguments with respect to the Establishment Clause, which I'm not going to have time to get into here. But I will be writing an article and publishing it in a few months. So on that side of things, I'll just leave it for that if anybody's interested to read it and give me their feedback. Thank you.
And since this panel started a little bit later, so we want to give full due to Professor Corbin's remarks. So just hold off on that martini.
And if Carol Burney is here, we have a phone message for you.
Carol, get your phone message. First, I do want to thank everyone who's made it possible for me to be here today. I very much appreciate it. So my presentation is a little different than Barry's and Rick's. Rather than examining Justice Rehnquist's religion clause cases to discuss his influences on religion jurisprudence, I'm actually going to examine his free speech cases to think about how he might have viewed a recent religion case, namely Burwell versus Hobby Lobby Stores Incorporated. As you all no doubt know, Hobby Lobby Stores, a for-profit corporation, sought a religious exemption from the contraception mandate, which required that its insurance plan include all FDA-approved forms of contraception, including 4 that the owners believed, erroneously, caused abortions. And a major question in the case was whether religious liberty rights should extend to for-profit corporations. The Supreme Court held yes. And I just want to note that while this case was brought under the Religious Freedom Restoration Act, nothing in the opinion really indicated it would have answered the question differently under the Free Exercise Clause. So this decision strikes me as completely wrong. There is reason to think that Chief Justice Rehnquist would have agreed that for-profit corporations should not have the right to religious exemptions, certainly not under the Free Exercise Clause. So just to be clear, I'm focusing on the claims of corporations as opposed to the corporate owners, right? Their claims should fail also, but for different reasons. All right. A little background on Chief Justice Rehnquist and free speech. Chief Justice Rehnquist regularly rejected the free speech claims of for-profit corporations. Right? So he dissented from the idea that corporations, for-profit corporations, have a right against compelled speech. Right? He said in Pacific Gas and Electric, "I do not believe that negative free speech rights applicable to individuals and perhaps the print media should be extended to corporations generally. He also dissented in First National Bank of Boston versus Bilotti, which held that the political speech of for-profit corporations ought to be just as protected as the political speech of actual people, and which served as the theoretical precursor to Citizens United. So there are a few themes that recur in Chief Justice Rehnquist's writing on corporate free speech. First, for-profit corporations, he thought, are artificial entities, and they should only have the rights that the state bestows on them. Right? He sort of insisted on that in Bilotti. Second, corporations really only need those constitutional rights that help enhance their efficiency as an economic entity. Right? So if it's not going to help them perform their economic functions, there's no need to give them that constitutional right. Third, people who chose to incorporate have to take the good with the bad. All right, so with that in mind, right, these views of for-profit corporations would probably not lead to a corporate right to religious exemptions. Right? So whether for-profit corporations are protected by a constitutional provision like the Free Exercise Clause depends not on whether the corporation is a person, but what the clause is meant to protect. After all, corporations have been extended personhood, but at the same time, the Supreme Court has not found that all constitutional clauses apply to corporations. So the real question is, why do we protect religious liberty? And given those reasons, does it make sense to extend religious liberty to for-profit corporations? So why do we protect religious liberty and religious conscience? Well, religiously inclined people might argue that we protect religious liberty so people can fulfill their obligations to God. Right? These duties are paramount, and a person's soul could be at risk. Now, a more secular justification might focus on honoring individual autonomy and dignity, which is a touchstone of constitutional rights. Right? One need not agree with someone's religious beliefs in order to conclude that there is value in respecting her decision to follow them. Religious liberty protection furthers individual autonomy and dignity by recognizing people's rights to make decisions about their spirituality. Whatever view you have on why we protect religious conscience, this constitutional right only makes sense when applied to actual people. The religious justification is, as Madison said, about protecting the relationship between man and her creator. His creator? I switched that at the last minute. Right? People suffer when they can't fulfill their obligations to the divine. Corporations, of course, are not sentient and cannot feel anything. Right? They don't have any sacred relationships, and they certainly don't have a soul. As for the secular justification of respecting autonomous decision-making, it's grounded in the idea that all human beings possess an inherent dignity, right? And that respecting people's religious conscience and autonomy is very much about respecting the inviolable dignity of the person. But while people, actual people, people like me, right, are ends in themselves and have inherent dignity, corporations do not, right? Corporations are not an end in themselves. They are merely a means to an end. They are legal fictions created to facilitate economic growth. Right? These instrumental, artificial entities do not possess any inherent dignity that needs to be respected. In short, right, the reasons we protect individual religious conscience just don't apply to for-profit corporations. For-profit corporations are not people, and they are not like people. They lack the fundamentally human attributes, whether it be a relationship with the divine or inviolable dignity, that justify religious liberty rights. In other words, as Justice Rehnquist often emphasized, the corporation is an artificial entity, not an actual person. And as he noted in his Bilotti dissent, which is one of my favorite all-time quotations about this, To ascribe to such artificial entities an intellect or mind for freedom of conscience purposes is to confuse metaphor with reality. All right, well, what about religious institutions? Right? Corporate religious liberty proponents argue that since religious liberty protection extends to nonprofit corporations like churches, then for-profit corporations should likewise be protected, as they are the same in all important respects. They are both institutions through which people exercise their religion. Actually, the justifications and appropriate scope of free exercise protection for churches is actually hotly contested. Right? One view is that any protection for churches is derived from protection for its individual members. And this view, that all religious liberty is ultimately rooted in individual rights, really offers little support for corporate religious liberty. But even assuming there should be protection for churches as churches, right, the reasons we protect churches do not apply to for-profit corporations. So one argument for protecting churches is that they're sacred. Right? They're the house of God. For-profit arts and crafts stores and other corporations obviously are not. Another reason is that churches are crucial to religious freedom because they're sort of the source of theological truth. Right? For-profit arts and crafts stores, not so much. In addition, the practice and promulgation of religion is the overriding purpose of churches. Again, this is obviously not true for for-profits. Right? By definition, for-profits exist to make money, otherwise they would be non-profit. Right? Finally, free exercise protection for churches assumes that the church is an association of voluntary members. This assumption that the church is a group of people who voluntarily join together to pursue religious goals is highlighted in the sole free exercise case, where the Supreme Court granted a religious exemption to an entity rather than individuals. So in Hosanna Tabor Evangelical Lutheran Church and School, which was mentioned earlier, the Supreme Court upheld the ministerial exemption, which sort of gives churches immunity from discrimination suits brought by their ministers. But in justifying this exemption, the Supreme Court emphasized the voluntary nature of the ministers' association. Right? It's permissible to exclude ministers from anti-discrimination law protection because they have voluntarily consented to the church's rather than the court's adjudication of their employment disputes. For-profit corporations, however, are not voluntary associations in the way churches are. Right? Employees are simply not members of a corporation the way they are members of a church. People join voluntary associations because they agree with the principles of the association. People take jobs kind of because they have to. Right? You could argue that while employment itself may be an economic necessity, employment at these particular religiously minded corporations is not. But this claim is neither empirically supported, and nor is it likely to be. Again, the reason churches are afforded free exercise protection, that they're sacred, the source of theological truth, their main goals and acts are religious, they are voluntary associations, they just don't translate to for-profit corporations. Once more, Justice Rehnquist has the perfect summing up of this point. Right? In dissenting about the recognizing compelled speech for corporations, he noted that it was a jurisprudential sin to treat as identical entities that are demonstrably different as corporations and people. All right, well, what about the owners? Right? Hobby Lobby court suggests that it was unfair that religious individuals should lose their religious rights when they join together as a for-profit corporation. Now, of course, the point of incorporation is to create a legal entity that is separate and distinct from its owners. Right? And if owners and their corporations are separate and distinct for purposes of limited liability, maybe they should be separate and distinct for purposes of religious rights. Chief Justice Rehnquist may have shared this idea that owners should not be able to have their cake and eat it too, as it were. Again, from one of his decisions rejecting free speech protection for corporations, he wrote, "In return for the special advantages that the state confers on the corporate form, individuals acting jointly through corporations forego some of the rights they have as individuals." This leads me to sort of my last point, which is that recognizing corporate religious liberty privileges the already powerful corporations over their employees. And so first, it opens the door for corporations to seek exemptions from laws that are meant to protect their employees. Right? If Hobby Lobby can deny contraception coverage, can a Jehovah's Witness corporation refuse to cover blood transfusions? Will corporations that oppose same-sex marriages be allowed to deny health benefits otherwise available to married couples? What might be challenged next? Second, corporate religious liberty will come at the expense of employees' individual religious liberty, because religious obligations can point towards contraception use as well as away from it. So, for example, some people believe that you should not bring new life into the world unless you are able to sustain it in accordance with God's intention for the life to be fulfilled. Granting an exemption from the contraception mandate to corporate employers will make it that much harder for employees to meet their religious obligations. In short, recognizing corporate religious liberty will exacerbate the power imbalances between employers and employees and really risks making religious liberty yet another luxury reserved for those at the top. And in his speech cases, his corporate speech cases, Chief Justice Rehnquist was also concerned about too much power going to the corporations. Now, his focus was a little different. Right? He was worried about corporate power leading to corruption and to the undermining of the integrity of the democratic process. But he at least was aware that granting rights to for-profit corporations have consequences, a recognition that seems quite absent in Hobby Lobby. In short, were Chief Justice Rehnquist faced with the question of corporate religious liberty, he might just have ruled against it. Thank you.
I got the signal from Dean Ryder, 10 minutes for questions, and we will just cut it off at the end and continue the questions at cocktail hour. So, questions?
I'd like to know what you think of the effect of the overpowering preponderance of Roman Catholics on the effect of the dilution of the church, the religion and government on such cases as Hobby Lobby, abortion, medical, religious school funding, and so on.
I think it's a fascinating development demographically and historically, and I think it's pretty sure that a lot of those at our founding would have been almost as surprised if they learned that the great-grandson of a slave was on the Supreme Court as they would to learn that there were not only just one but 5 Catholics on the Supreme Court. So demographically, it's fascinating. I'm not one of those who wants to be too quick to ascribe the outcomes to sort of, a papist plot to yield results that are congenial to the church. I think all of the justices, I believe this of the justices on the left, right, center, Jewish, Catholic, if we had Protestant justices anymore, maybe those two, do their best to identify the content of the law and to follow it. And I think that's true of Justice Scalia, although he's Catholic, and I think it's true of Justice Breyer, who's Jewish. And so I guess I'd have to respectfully push back on what I think might have been the premise, that it's because they're Catholic that they vote the way they do in a case like the partial birth abortion case or the school voucher cases. I think the story is much more likely to involve things like Republican presidents rather were elected for a number of years, and they wanted to pick judges who were pro-life because that's what their constituents wanted, and a whole lot of the justices who were pro-life, who had the credentials necessary to be considered seriously for the court, were Catholic. That's going to change in future years because there's a whole lot more very well-credentialed evangelical Christian lawyers now who are going to be available to be appointed by presidents who oppose abortion rights.
So I have to confess that I wonder how some of the decisions we have would have come out had we had 9 women on the bench rather than 9 men. But the only empirical study that I'm aware of that focuses on religion compared judges' ruling on Establishment Clause claims, and they looked at Christian judges versus Jewish judges. And it seemed that Jewish judges were much more attuned to, or that's my spin on it, the straight-out fact is Jewish judges were more likely to find a particular practice violated the Establishment Clause than the Christian ones.
I'll just quickly note that isn't Justice Sotomayor, isn't she Catholic? And she's voting on the other side of the issue usually, so I'm with Professor Garnett on this one.
I was wondering if you foresee the government challenging sincerity in the future.
The question was whether they perceive the government challenging the sincerity if someone's seeking an exemption in the future.
Yeah. Is your question whether the court will be, right now it's willing to scrutinize claims as to whether a sort of a claim for exemption is sincerely sought or not? So is your question whether they'll continue to do that, or?
It seems to me the government punts on sincerity a lot, and I was wondering if they, after Hogwarts, will stop doing that.
Well, right now, in terms of at least the claims from generally applicable laws, what's happening is that rather than sort of, let's say that the justices think that there's sort of a wild claim for a religious exemption. Right now they're saying, well, we can't question the truth of that. We can't, we can't, the truth of the belief itself and sort of whether the claimed exemption is central to that person's religious practice. But we can sort of look into whether, they seem to be sincerely requesting an exemption or not. So it's a device that they're sort of using now as a proxy for when they think that, a religious belief is sort of out there on the margins in terms of defining religion and not defining religion. So at least I don't think the court is going to jettison that tool anytime soon.
So here's a story along these lines. I think it's a great question, Nathan. I think you're right that the way the cases have played out means that there's going to be a lot more action there. When I was clerking on the Court of Appeals, my wife, Professor Garnett, was clerking for a judge down the hallway, and they had a case about a guy in prison who wanted to grow his hair long for religious reasons. And he claimed it was because he was Rastafarian. And apparently the warden had gone to somebody in the prison who was sort of the acknowledged leader of the Rastafarian community in prison and says, "Is this guy one of yours?" And they said, "No, we've never seen this guy. He's not one of us." So they denied the exemption from the grooming requirement. Then the guy apparently said, "Well, I'm a Sikh." And so they go to the guy who's in charge of the Sikhs kind of in the community and said, is this guy one of yours? And they said, "No, we've never seen this guy. He just wants to grow his hair long. He's insincere." So the warden denies it on the ground that the objection was insincere. And so then the guy, being very creative, flips through his Bible, recalls the story of Samson, and takes the vow of the Nazirite. Now, it's not clear how many people have taken the vow of the Nazirite since Samson, but this guy took it. And the warden was kind of in a bind because the guy said he was sincere and they didn't want to have to second-guess him. The way the case turned out, the guy lost anyway, but it's an interesting example of how the sincerity thing becomes the vehicle for dealing with a lot of these cases.
Yeah, so I understand your question is that courts, even though it's officially part of the analysis, they're usually extremely deferential because it bleeds too readily into questioning the religious beliefs themselves. and given that they've become, and given how deferential they were in Hobby Lobby, because there were a lot of factual issues that might have raised questions about the sincerity of Hobby Lobby and their beliefs. So, for example, they used to cover these until Obamacare, or they used their money for their retirement funds went into companies that supported it. But none of that seemed to have entered the analysis. So I think it will continue to exist formally and continue to not be used except maybe against prisoners.
One more. Andy. Chris.
I wonder if you could apply these questions about exemption and sincerity to other public health mandates like vaccines. I guess the conventional wisdom when I teach as to my health law students is that after Jacobson and the police power of the states, that there's really no religious barrier or other constitutional barrier to these sorts of mandates, as long as they're applied reasonably. But does RFRA and these analyses change that conventional wisdom?
I'm not quite sure what your question is. If your question is, would they have a claim under RFRA?
Yeah.
Yes, they would be able to argue this imposes a substantial burden on our religious beliefs, presuming it was a religious belief and not a non-religious belief, because RFRA has not yet. So corporations' religious beliefs are covered. People's non-religious, deeply held conscious beliefs are not covered under RFRA. And then the question would be, does it pass strict scrutiny? And that'll depend how a court decides to apply it. You could easily make a claim that it does, right? There's a compelling government interest in not having babies die, right? And this is well tailored to accomplish that interest. But another judge might.
And it may depend on the science of what percentage of vaccine coverage we need to get herd immunity as well.
So again, though it's strict scrutiny, you can still come out differently, even applying the same test.
And right now, it's sort of a political discussion in the state legislatures. Do we grant a conscientious exemption for vaccines, a religious exemption, or just a personal reason exemption, as I believe California does? And so all the legislators are sort of politically considering narrowing it just to a religious claim. And if that happens, and the only way that they think they can get out of a vaccine is by claiming a religious exemption, then I think you're going to see, again, the court sort of applying this sincerity test a lot more rigorously to sort of police what they feel to be our true religious claims versus, insincere claims.
It's not the only area where they've been deferential to the organization. I think of the Boy Scouts case, too. And there's a lot to be said for not allowing the court to rummage around in associations' claims of what's central. So we'll end with the immortal words of Ann Richards, the former Texas governor, who didn't care if there was a nativity scene at the state capitol because she said it was good to see some wise men there. Thank you, everybody.
Thank you so much for doing this.
You guys are great. Thank you.
Nice job.
Let me give one more thanks to all the panelists and the moderators, and thanks for all of the guests who came today. And now there will be a reception up on the rooftop. You can get there up the stairs right out here, and there's an elevator right next to it. Thank you.